Hi, my name is Hosea Masinga and I'm a case officer at the National Consumer Tribunal. Today I will be advising you on how to file an application to review a decision not to issue a clearance certificate in terms of Section 71(3) of the National Credit Act. This type of application is filed by the consumer directly with the tribunal if the consumer has satisfied all the obligations under every credit agreement that was subject to the debt rearrangement, except for mortgage agreement or other long-term debt, and the debt canceller refuses to issue a clearance certificate. The consumer will apply to the tribunal to review that decision. If the tribunal is satisfied that the consumer is entitled to the clearance certificate, the tribunal may order the debt canceller to issue a clearance certificate to the consumer. The projected table provides an overview of the step-by-step processes involved in filing a Section 71(3) application. There are certain instances that impact the usual process, such as other interlocutory applications. This is any application that must be argued prior to the next stage of the process identified in the previous slide. Common examples include the late filing of affidavits, applications to amend documents, or failure to meet the filing requirements. The projected table provides the guidelines on how to file a Section 71(3) application. These guidelines are guided by the tribunal rules and are available on www.thenct.org.za. There are certain documents that are required in column D and E as projected in the previous table. These documents are a filing notice, which is Form TIR 30A, and the application form, which is Form TI 71, so paragraph 3. Other documents are a copy of the agreement or the magistrate's court order whereby the debt was rearranged, a copy of the application to the debt canceller, including any receipt of other documents to prove obligation arising from the agreement. If available, the debt canceller's reasons in writing for deciding not to issue the clearance certificate. Proof that the consumer has settled all obligations except for the mortgage agreement or other long-term debt and can demonstrate the financial ability to satisfy these remaining obligations. Proper service must be effected before the tribunal accepts an application. Service can be done personally, via email, fax, or via registered mail. With regards to personal service, the person signing for receipt must include their name, surname, and designation. Courier service is also a form of personal service. In addition, you can serve via email and thereafter follow that up with personal service to expedite. In this instance, file after personal service was done. With regards to email or fax service, consent to service must be obtained. Such consent must be specific and relevant to the service of the application. Service by registered mail can also be done. The registered mail slip must be stamped and dated at the post office. Should the service use not apply, kindly contact us for further assistance. The consumer must serve the debt canceller from whom the certificate is to be obtained a copy of the Form TI 71(3) and Item 4 of Column E as provided in the table projected in slide number 4. Once we receive your documents, we screen your submission and decide to issue a notice of filing. However, that is if we are satisfied with the submission. Alternatively, we issue a notice of incomplete filing with guidance on how to file in a manner that the submission will be accepted. We do this to ensure that you are able to provide all the relevant information for the tribunal to adjudicate on your case. And that is how to file an application to review a decision not to issue a clearance certificate in text of Section 71(3) of the National Credit Act.